Judgment in the matter of Simkova against Secretary of State for Work and Pensions.
This appeal is concerned with social security benefits. In particular, it's concerned with the child element of universal credit. Ms. Michaela Simkova is a Slovakian national resident in England with a permanent right to reside in the United Kingdom. She claims entitlement to the child element of universal credit in respect of her son Markus, who at the relevant times resided with his grandparents in Slovakia. Universal credit was introduced by the Welfare Reform Act 2012. It includes an amount for each child or qualifying young person for whom a claimant is responsible, the child element. A person is responsible for a child or qualifying young person who normally lives with them. Ms. Simkova does not qualify for the child element of universal credit under domestic law because, although she paid for his upkeep, Markus lived with his grandparents. However, Ms. Simkova claims that she has a directly effective right under European Union law. In particular, she relies on an EU regulation on the coordination of social security systems, the Coordination Regulation. This coordination regulation continues to have effect in the United Kingdom despite the withdrawal of the United Kingdom from the European Union, because of the Withdrawal Agreement between the United Kingdom and the European Union, which is given an effect in our domestic law by Parliament in the European Union Withdrawal Act 2018. The coordination regulation applies to national legislation concerning branches of social security, which it identifies as including family benefits. The parties to this appeal agree that if the coordination regulation applies, Ms. Simkova would qualify to receive the child element of universal credit. This is because the coordination regulation entitles Ms. Simkova to family benefits as if Markus were residing in the United Kingdom. The issue, therefore, is whether the child element of universal credit is a family benefit within the meaning of the coordination regulation. In addition, Ms. Simkova invites the Supreme Court to consider whether to refer this issue to the Court of Justice of the European Union pursuant to the Withdrawal Agreement. On the 26th of July 2017, Ms. Simkova made an application for universal credit, including a claim for the child element in respect of Markus. The Secretary of State for Work and Pensions decided on the 1st of September 2017 that Ms. Simkova was entitled to universal credit, but eventually decided that Ms. Simkova was not entitled to the child element. Ms. Simkova appealed to the First-Tier Tribunal, which on the 19th of August 2020 allowed the appeal and awarded the child element. The Secretary of State appealed to the Upper Tribunal, and on the 21st of February 2023, the Upper Tribunal allowed the appeal and decided that the entitlement to universal credit was to be calculated without the child element. Ms. Simkova appealed to the Court of Appeal, which on the 26th of April 2024 dismissed the appeal. Ms. Simkova appeals against that decision to the Supreme Court. The Supreme Court unanimously dismisses the appeal. Lord Lloyd-Jones and Lady Rose give the judgment, with which Lord Hamlin, Lord Sales and Lord Richards agree. The coordination regulation contains rules for the coordination of national social security legislation, which fall within the framework of free movement of persons. These rules determine which member state is responsible for providing which social security benefits in the context of free movement of persons. If the coordination regulation applies, the applicable law would be UK law, and Ms. Simkova would qualify under the regulation to receive the child element of universal credit. The question, therefore, is whether the child element of universal credit is a family benefit for the purposes of the coordination regulation. The classification of a benefit under the coordination regulation is a question of EU law. However, that classification must be conducted by reference to the substantive characteristics of the benefit in national law. two conditions must be satisfied for a benefit to be regarded as a social security benefit under the coordination regulation. First, the benefit must be granted to recipients on the basis of objective criteria without an individualized assessment of need. It was common ground before us that both universal credit considered as a whole and the child element of universal credit meet this condition. Secondly, the benefit must fall within one of the branches of social security listed in the coordination regulation. The parties agree that universal credit considered as a whole cannot be a coordinated social security benefit under the coordination regulation because the overall purpose of universal credit is poverty relief. Therefore, Ms Simkova can only succeed in her claim to the child element of universal credit if EU law requires the Supreme Court to consider the child element as a freestanding benefit. The Court rejects Ms Simkova's submission that the child element of universal credit is severable from universal credit as a whole. In the Court's view, no analogy can be drawn with child tax credit, which was a freestanding benefit and which was regarded as a family benefit within the coordination regulation. The child element of universal credit has now replaced child tax credit and is deeply integrated into a generalized composite benefits scheme. The integration of the child element into universal credit is a matter of substance and not of presentation. The Court further considers that there is no basis or authority for treating different components of a single benefit as being open to separate characterization under the coordination regulation. Nor do the authorities relied on by Ms Simkova reveal an emerging doctrine of severance in which different elements within a single benefit are to be treated as separate. In the Court's view, severance is not the sort of regulatory mechanism or principle that can be implied into the detailed and complex regime of the coordination regulation. In the light of the clear conclusion to which we have reached in relation to this substantive issue, it is not necessary to decide whether the Court has the power to make a reference to the Court of Justice of the European Union under the Withdrawal Agreement. The Court is now adjourned.